Great. Well, good morning and good evening, everybody. I'm excited to have all of our members and guests here today. For those of you who have not attended these monthly legal digital roundups in the past, you're in for a real treat. In the next 45 minutes to an hour, we'll go through a series of updates on what's going on in India from a legal and judiciary perspective. We have a team, a superb team, I should add, of legal experts from Khaitan and Company, and they will provide a briefing in sort of a nightly news format, and after which we'll have an opportunity for questions and answers. Please note that this call is being recorded, so that you just understand that as well. And in addition, the slides will be shared afterwards, so don't feel like you have to take screenshots or take notes. That said, we do encourage people to ask questions. In order to do that, you can raise your hand or type it into the chat. We'll have a distinct section afterwards where there'll be some questions and answers. With that, I'm going to hand it over to our Khaitan and Company team. Over to you, Tanu, to kick us off today.
Thank you, Jay, and thanks to USIBC also. A very warm welcome to our audience today. Thank you for joining us. I hope everyone's doing well. We run this session periodically with USIBC in a newscast format, largely because, like Jay said, there's a wide variety of topics that we cover in the digital ecosystem in India. Our partners from Khaitan & Co. present here today will be correspondents for the newscast, and will give you an outline of major developments in their respective field of expertise. I'm going to quickly introduce our speakers today, starting from the top left. First, we have Supratim Chakrabarti from our Kolkata office. Supratim leads our data privacy practice and is also quite active in the technology space. We then have Pranjal from our New Delhi office, who's part of our competition and antitrust practice. Next, we have Abhinav Chandan, also from our New Delhi office. Abhinav is a TMT lawyer and especially focuses on telecom. We then have Ishan Johri from our Mumbai office. She is a specialist in technology and media laws. Does a lot of fun stuff in this space. We have Sarthak Parmani, who's a direct tax lawyer based in our New Delhi office. And finally, at the bottom right is me, Tanu Banerjee. I happen to be a TMT lawyer as well, based in Mumbai. But for today, I'll be the moderator for the session. Going to our next slide. This is our agenda for today. First, Supratim is going to take us through the recently announced National Data Governance Policy and also a recent amendment to the IT rules with respect to grievance appellate committees that the government proposes to set up. Next, Sarthak will take us through some proposed amendments to the tax regime for online gaming platforms. Abhinav will talk about a recent proposal from the Telecom Regulatory Authority of India regarding digital connectivity infrastructure providers. Pranjal will take us through the most widely talked about ruling in the Google Android case. And finally, Ishan will talk to us about the glamour world with some guidelines on celebrities and influencers. With that, I'm going to bring in Supratim to kickstart our first session. Over to you, Supratim.
Thank you, Tanu. Good morning, good evening. So I think I'll take two updates like Tanu mentioned. Short ones, but very important, at least for USIBC members. The first one is the National Data Governance Framework Policy. Why we are talking about it is because this has been in the news for some time and we have been working or discussing this because it has got elements of anonymized data and non-personal data also involving private players apart from government's play in this. Okay, so let's first understand very quickly what has been the chronology of events that have taken place in relation to this this thought process of having such a policy. So in September 2019, MeitY, which is the Ministry of Electronics and Information Technology, constituted a committee of experts for non-personal data governance framework. In July 20, the expert committee released the draft report for public consultation. In December 20, the expert committee released a revised report addressing several concerns which were raised in relation to the draft report. In February 2022, METI released a draft India Data Accessibility and Use Policy to enable sharing of government data. However, this was later withdrawn. And then in May 2022, we had this National Data Governance Framework Policy. Now, interestingly, in the budget speech, our finance minister mentioned that there'd be a national data governance policy, which will be released soon to unleash innovation and research by startups and academia, and also enable access to anonymized data. What is unclear is whether she alluded to the May 2022 draft or that draft with some changes or an absolutely new draft. Nonetheless, I think it's important to just look at that May 2022 draft, which is kind of the latest, and we could largely see some portions or most portions could be taken from there. So first, let's discuss what are the key provisions in relation to the draft. The aim is to launch a non-personal database program and provide for methods to ensure that non-personal data and anonymized data, both from government and private entities, are safely accessible by research and innovation ecosystem. Um, Now, what happened? Aside from that, I think let's also understand to whom it is applicable. They say that the government departments it's applicable to and covers data collected and managed by any government entity. They have also said will encourage state governments, and then separately it mentions that it is applicable to non-personal data sets. Okay. Objectives of this policy includes to have a standardized data management and security standard, to promote transparency, accountability, and ownership in relation to non-personal data and data set access, to set out quality standards and promote expansion of India datasets program and overall non-personal data ecosystem. They've also been now harping quite a bit otherwise that the government will set the parameter or standard in relation to anonymization. There is a thought process of having certain institutional framework, which is establishment of the India Data Management Office, IDMO, under Digital India Corporation, which will be under the METI. I'd like to pick up a couple of points from that particular draft of May 22. And I think we have discussed this a bit previously in other gatherings of USIBC, but this is very important to take note of. This is the role of the IDMO. In one of the point, it says IDMO will enable and build the India Dataset Program, which will consist of non-personal and anonymized data sets from government entities that have collected data from Indian citizens or those in India. So citizenship as well as residency, both are relevant here. And then it says private entities will be encouraged to share such data. At another place, it says the IDMO will notify rules to provide data on priority / exclusively to Indian / India-based requesting entities. There was some discussion that we should probably look at the final draft and then discuss internally what actions we should be taken from USIBC perspective, in relation to such data sharing. So that's about it in relation to this update. I'll move on to the next one, which is the IT rules and the constitution of grievance appellate committee. As you would all be aware that the present mechanism that are set out in the IT intermediaries rules is that each intermediary should have a grievance officer. And if you are a significant social media intermediary, which is a higher threshold of social media intermediary, then you need to have a grievance officer who's resident in India. An amendment was carried out, and it was envisaged that there will be a grievance appellate committee, one or more of them, within 3 months. And what the minister said is that, listen, ordinarily, we would not like to get into such an arrangement, being an arbiter, ombudsman, whatever you call it. But because there are so many grievances which are unattended or inadequately attended, we are forced to bring about the grievance appellate committee mechanism. So GSE will basically be an additional avenue available to users for grievance redressal. How will it operate? Persons aggrieved by a decision of any grievance officer in relation to any intermediary may prefer an appeal to the GSE within 30 days of receiving communication from the decision from the grievance officer. The GSE will operate largely on an online basis to endeavor and would endeavor to resolve the appeal within 30 days of calendar days of receipt of the appeal. Intermediaries are required to comply with the orders passed by the GSE and upload a report on its website. So quite, I would say a mandatory kind of arrangement, which would perhaps come into play. What is the current development? Why are we talking about this? Because on 28th of January 2023, three GSEs have been established, and they have named it GSE 1, 2, and 3. These are headed by officials from the Ministry of Home Affairs, one by Ministry of Information and Broadcasting, and the third one by Ministry of Electronics and Information Technology. Officials from there. And then these GSEs will be operational from 1st of March 2023. They have given a web link. If you click that, it is presently showing that it will be soon up and running, but presently it's not there. So that's about it from a update perspective. Very happy to take any questions if they're there in relation to this
So, but then
pieces.
quick follow-on questions. I think I'll go back to the national data governance policy first.
Yeah.
And I noticed that you sort of said that largely this is a more functional policy than its predecessor. But just given that our central data protection law itself is not in force as yet, although there's so many discussions and drafts that are being discussed, do you sort of see that there'll be perhaps some sort of issues in implementing this?
See, probably there'll be not too much of an issue because they try to dissect it into two parts. The personal data element of it is completely taken care of in a way by the DPDP bill, and the non-personal data related framework would be under this policy. That's the thought process, and you could probably see some interlinkages between the two, of course, but largely they should not be too much of an issue, I believe.
Right. And on the GSCs, I know that you said that this is a grievance sort of appellate committee, but does it only have appellate jurisdiction if a user wants to make a complaint? Is it possible for the user to approach the GSC directly? How's the government looking at that?
It is right now. I think the construct the way it is basically an appellate committee. So if you are within 30 days of receiving a communication from the grievance officer, you can approach the GSC for as an appeal.
Right. Great, thank you for that, Supratim. I'll bring in Sarthak now, who's going to talk about the gaming world. Over to you, Sarthak.
Thank you, Tanu. So, a very fascinating and relevant topic across the world today is the online gaming, and India sees this no differently. The gaming industry in India was valued around $2.6 billion recently, and is expected to increase manifold in the coming years. Now, the Indian taxing government has seen this as a great opportunity to bring specific taxing provisions for the online gaming industry and ensure certainty for the online gaming companies while carrying out their withholding tax obligations. Just as a quick background to the existing law that's in place. So there are no specific provisions for online gaming companies as of today, but the provisions are borrowed from a generic provision which require the gaming companies to withhold tax at the rate of 30% on winnings that exceed INR 10K or a dollar equivalent of 120. Now, while this seems as plain vanilla as a provision could be, but believe me, when it comes to the world of online gaming, it comes with a lot of issues. The three foremost issues are here in front of everyone. And beginning with the first one, whether winnings should be considered net or gross. So just to take a very quick example on that, if a player buys in at 10 and wins a pot of 100 at the end of the game, so the provision now requires withholding to be done on the amount of winnings. But whether they require it to be done on the net winnings, that is 90 in this example, or the entire 100. Now, this has been subject to a huge amount of litigation in India and has led to different views by the online gaming companies vis-a-vis the taxing authorities. And has also led to huge exorbitant demands being raised against online companies for adopting a different view. The second issue that becomes relevant to discuss is the threshold of INR 10K or the USD 120, that whether it should be considered on a per year basis or whether it should be considered on a per game basis. Now, while the online gaming companies as well as the gamers are inclined towards considering it towards on a per game basis, the taxing government in India considers this to be on a financial year basis and requires the online gaming companies to withhold tax once the threshold it crosses INR 10K in a given financial year. The third relevant issue that becomes important for consideration is the timing of carrying out these withholding obligations. Now, there are two possible views around this. One, that whether the withholding obligation should be carried out at the time of credit to the wallet of each player, or whether it should be carried out at the time of withdrawal by the player of the relevant winning in his wallet. Now, as part of the budget proposal that has come on 1 February 2023, the government has tried to address most of these issues. As a very, very welcome move, specific provisions have now been introduced to online gaming companies, which are sought to be made applicable from 1 July 2023. And what brings as a very great comfort to the online gaming companies is the concept of net winnings. So the new budget proposal introduces a concept of net winnings, the position that has been traditionally adopted by the online gaming companies for carrying out their withholding tax obligations. The second clarification that the budget proposal has also introduced is with respect to the timing of withholding. Now, the withholding is required to be undertaken by these online gaming companies at the time of withdrawal by each player from the wallet with the gaming company. And second, the gaming companies are also required to withhold tax at the end of financial year on the accumulated balance of winnings that is there. While amidst all of these changes, the tax rate that was there as 30% remains the same. An interesting development that has happened along with these clarifications is the government stand on the threshold of INR 10K. Now, very interestingly, the government has said that the intention of the government was always to have this INR 10K as a per financial year model. And therefore, now going forward, the INR 10K has been completely done away with in the specific provisions for online gaming industry. So now taxes will need to be withheld irrespective of the amount of winnings involved. While these changes have brought great amount of certainty, few certain points need to be kept in mind going forward. One, that is how these net winnings will be computed is a very crucial element and will need to be considered as and when the government prescribes the mechanism for it. Second, the online gaming companies will need to be mindful of the liquidity position that they have to carry out the withholding tax obligations at the end of the financial year. Third, one will need to assess the impact of removal of the threshold of INR 10K or the dollar equivalent of 120 on the pending cases as of date, given the intention of the government on removal of INR 10K threshold in entirety. Happy to take any questions on this.
Great. Thanks, Arthak. Very interesting, of course. But I was curious to know I noticed that your presentation says that this withholding or the new withholding tax regime will apply from July 2023. But our financial year here in India starts from April. Is there anything that gaming companies could consider in particular during this transition period?
That's a very interesting question, Tanu. So what the government has done is also introduced or proposed an amendment to the existing withholding provision, wherein they have clearly made the INR 10K threshold to be considered on an annual basis. So now going forward during the transition period from April to June 2023, the online gaming company should be mindful that the INR 10K threshold is to be considered on a per year basis and not on a per game basis.
That's a lot of reworking, I guess, for the game platforms. Great. Thank you, Sarthak, for that. I'll bring in our next speaker, Abhinav.
Thank you, Tanu, and hello, everyone. We'll now breeze through some important aspects of a new consultation paper that the Telecom Regulatory Authority of India has just floated last week. for creating a new category of infrastructure providers for the telecom sector. We'll look at two major potential upsides of this development, one in terms of logistics, operations and optimization, and the other in terms of investment opportunities. So as you can see on the screen, telecom entities fall under three brackets currently. Without going into detail, buckets 1 and 2 are full-fledged telecom licensees under the unified license regime, and they are bound by extensive compliances and substantial license fee obligations apply on them as well. The third and the main bucket for this discussion is that of the passive infrastructure providers, which has been around since 2000. These are entities which are in the business of setting up of shareable passive infrastructure. For example, telecom towers and dark fibers, which are relatively innocuous part of the telecom network and not part of the core telecom network and do not require a full telecom license to own and provide. These entities only have a registration with the Department of Telecom with only minimum compliances entailing. But they are crucial in the sense that they are able to establish the hundreds of thousands of telecom towers and as many miles of optical fibers which are necessary for telecom connectivity, and which then they provide to all their telecom licensee customers under buckets 1 and 2 on a non-discriminatory and multi-sharing basis. These are mostly long-term leases with a cost-plus model. They are unable to provide services to end users directly. They can only provide their infrastructure and services to the telecom licensees as of now, which is a restriction. Their job basically is to reduce the CapEx, OpEx, logistical and operational stress and pains of the telecom licensees, which has been a huge help. But one gap which has remained is the active infrastructure part. There is no category of neutral entities who can provide both passive and active assets on a multi-sharing basis to telecom licensees. And we have to see this in the context of 5G and the emerging tech and services that are upcoming and why this is important at this point. For example, artificial intelligence, M2M, and all the convergence that is happening. 5G requires network densification since the 5G waves do not travel far and have lower penetration through building walls and obstructions. More towers are needed. More towers are connected to need to be connected by fibers. All of this will be a huge cost, and 5G spectrum price was already off the roof. Plus, there is the requirement of importing new active equipment for 5G, which will also be an additional import cost. And even though 5G has been launched, it is currently only limited to major top-tier cities in India. So in order to speed in the proliferation of 5G and the upcoming emerging technology and services, DOT thought that it is time to have a new mixed entity, which is neither a full telecom licensee nor a simple IP1 registrant, which can own and provide all passive elements like an IP1. It can do basically everything that an IP1 can do, but it can also own and provide certain limited active elements as well. Not all, but some, which will obtain a license, but without having to face any of the bitter flavors of having a license. Although this is just as at a consultation stage by TRAI on DOT's request, TRAI has only posed questions for industry stakeholders at this point, and it has also proposed a light touch license draft for comments. But this is overall a great time for all stakeholders and their investors to put together their views for the regulator on how the proposed regime should be. The first aspect is, of course, the scope of elements, active elements that the new category should deal in. TRAI has named Wi-Fi, radio antennas, feeder cables, transmission links to be part of this licensed activity. They are part of active assets as well. But it has also excluded core elements specifically like switching centers and spectrum. Although it is the TRAI itself is still confused of what the definition of core should be in today's context. which we'll have to see based on the stakeholder comments that go in. According to TRAI, this license would be in the form of another authorization under the UL instead of a full separate license altogether, but with a much watered down version of the compliances. The biggest commercial relief we will see is that TRAI is pushing for license without a license fee, much like in the case of IP1 entities, whereas the telecom licensees pay a substantial portion of their revenue as license fee. Unlike for IP1, there will be a small entry fee and a nominal processing fee. The licensees will not be providing telecommunication services to end consumers directly, which is the same as IP1 entities. And for ensuring quality and service and security compliance and compliance for breach obligations, the TRA suggests that telecom licensees can contractually pass on these to these licensees, to the DCIP entities. And there is a small penalty, not small, relatively small penalty compared to telecom licensees of 20 lakhs, which can be imposed per event for breach events. All this is logistical and operational support, but the one key point that we have to focus on here is the investment opportunity, because when the IP1 entities came for the first time, telecom licensees had demerged all their passive assets and undertakings into another non-licensed IP1 entity. They garnered investments, monetized these assets, and shared with other licensees and generated revenues. We should expect that something like this will happen for the active assets as well if this goes through. So it will be good to see how many North American and Middle Eastern funds take interest in this. That's it from my side. Over to you, Tanu.
Thanks, Abhinav. Very interesting, of course. But I was just wondering before we, move on to our next segment, how does the current, IP1 framework, and of course, this is a consultation paper right now, so everything is proposed, so to say. But how does the current framework then interplay with the proposed DCIP regime?
Okay. So like I was saying that IP1 entities, they provide passive infrastructure. The DCIP entities will also provide passive infrastructure. They will also they'll provide some active assets as well, which will be named. The interplay will be in as follows. The IP1 entities have been allowed to migrate into this DCIP regime as well. And that is how they can continue providing services as well as go into other business model, or they can choose to remain as an IP1 entity and continue their current business. It's up to them.
Understood. It will
Yeah.
be good to see what comes out of this eventually.
Yeah. Yeah, exactly.
Thanks, Abhinav.
Thanks.
Time to bring in Pranjal. Hi, Pranjal. Over to you.
Hi, Tanu. Thanks, Tanu. So I think many of you would have already heard about the two Google cases. This came late last October, and it was almost of sorts swan song of the chairperson just who demitted the office in October last year. So two cases. The first one, the Android case, is the larger one, sets the context. It came up first. Both the cases were investigated together. Android case was largely centered around, Google's abuse of power associated with its dominant position in a host of markets, but essentially the licensable smartphone operating system market. And the CCI's version of the case was that, because it has such overwhelming dominant position in licensable operating system market, it has other services which are all linked to it, and it sort of has sort of, taken together the entire looking at the other services, has sort of used those other services to self-prefer itself in a lot of ways. And in this respect, CCI has looked at the case from the aspects of device manufacturers as well as app developers. From the perspective of device manufacturers, CCI found that device manufacturers are forced to pre-install a host of Google apps as a condition to get access to the Android platform for their mobile phones. And as we know, outside Apple, which is a non-licensable operating system, if any device wants to get access to a licensable OS, pretty much Android is the only option. So CCI's version was that because they have such an advantage with respect to mobile OS, that is Android, it forced all the device manufacturers to pre-install a host of Google apps. And not only pre-install, but also choose the placement of those apps in the Android platform. And that CCI held to be abuse of dominant position. With respect to even app developers, what CCI found was that app developers are pretty much logged in to develop apps for the mainstay Android platform, and the Google doesn't allow any other form of apps. It doesn't provide the SDKs, the software development kits, and the APIs for development of apps outside the Android's core operating system. So, for example, if someone would want to create an app for Android Fork, which is sort of a different version of Android, which although in the name is open source, but if someone would want to do that, that wouldn't be possible. So CCI found that looking at host of factors, that Google has abused its dominant position with respect to licensable OS market, and it has also abused its dominant position with respect to leveraging its position in Play Store, where it then ties a host of other apps to get access to the Play Store, which essentially is the window to host of other apps that we see on the mobile platform. So looking at all of that, obviously there was a penalty on Google, but more importantly, there were a host of directives on Google, and that has been in the news of late as well. So most importantly, CCI ordered that Google must allow any app to be side loaded on the Android platform, and that has caused a huge furore in the entire digital market space. Obviously, there are new age Indian apps, a lot of payment apps, a lot of upcoming apps who are strongly behind CCI and its order. But at the same time, from a Google's perspective, it feels very strongly about the directives issued, including side loading. There are a host of other directives, including, for example, the device manufacturers to be allowed to choose from the bouquet of apps that Google has. So on the other case that we see here, the Google Play billing system, this was a much simpler case where the CCI found that for any app that is on the Android operating system, it could and whenever they are paid, so those could be installed on the phones only if the users and the app developer agreed to use Google Play's billing system. And even for in-app purchases, so that is when apps are already downloaded, but for certain services, there is a separate feature that could be purchased. For that, when the payments have to be made, even for those, the Google's own billing system have to be used. And Google found that, CCI found that to be abuse of dominant position as well. And it found that Google self-preferred itself, in terms of self-preferring its Google Pay app, because it relied on what is called the intent flow system, which could help users in paying for their app purchases directly from that window, whereas for other UPI based billing systems such as, for example, Phone Pay or Paytm, that were based on what is called collect flow system, where they would have to shift to another screen for making those payments. Although Google vehemently denied those allegations, saying that those are available to other apps as well. But ultimately, Google was penalized by CCI with respect to this conduct as well, and host of directives, including the requirement that any app should be free to use any payment system or payment processor of its choice and shouldn't be restricted to Google Play billing system.
Okay, thanks, Pranjal. I'll quickly have a follow-on question, maybe just 30 seconds or less because we'll run out of time. But, obviously this is sort of an unusual order, or so it seems to me, given that in the entire ecosystem of app developers, app stores, and so on, there must be established business practices already, right? So does it sort of seek to undo those practices, and how do we see that going forward?
Yeah, indeed. I think these measures are quite serious, because CCI practically is asking all these entities to undo the very business practices that have led them to the position that they are in right now. So, for example, for Google, if those pre-installation of apps aren't going to happen, or the or Android folks are allowed to thrive in the way the CCI wants it to happen, that will probably undo the entire business model that they have. And therefore, it has a lot of significance, because in appeal, generally we see that these orders are never stayed, and they are heard, and obviously until they are heard on merits, these will not undergo a change. And therefore, if these are not stayed, that can lead to a permanent change to their business practices, effectively doing away with their basic business model. So, I mean, and we know that in Supreme Court has already ordered here that it needs to be there will be no stay, and therefore we have to see how Google tackles this issue. But a lot of things are still to unfold in this area.
Okay. Great, thanks a lot, Pranjal, for that.
Sure.
We'll move on to our final segment for today with Ishan, who's going to talk about celebrities. Over to you, Ishan.
Thank you, Tanu. In the final segment for the roundup, we'll just dive into legal updates relating to digital advertising. Just for setting some context, advertising in India is regulated in two ways. One, by the Advertising Standards Council of India, which is a self-regulatory body, and issues guidelines to advertisers and endorsers from time to time. The other is by means of various legislations, such as those in relation to the consumer protection, in relation to television broadcast, print publication, etc. Now, in this background, and in view of booming social media marketing and influencer marketing, the Ministry of Consumer Affairs in India recently issued a know-how document for endorsers who endorse products and services on social media platforms. This was directed specifically at celebrities, influencers, and virtual influencers. These know-how documents are more illustrative and explanatory in nature and emanate from a previously notified guidelines, which is guidelines for prevention of misleading advertisements and endorsements for misleading advertisements in 2022. The know-how specifically applies to persons who have access to a large audience and who has the ability to impact or affect the audience's purchasing power or purchasing discretion, rather. Interestingly, they are also applicable to virtual influencers. Virtual influencers are digital characters who have been provided with a personality and who interact or engage with users on social media platforms as if they were real persons. The requirements for compliance under the know-how document get triggered when there is a material connection between the endorser and a brand. As you can see, material connection has been defined in a very, very broad manner. And it includes monetary compensation, such as a fixed fee, or benefits such as free products, trips, hotel stays, etc., and even a relationship between the brand and the influencer or endorser or their family. There are two key requirements under the know-how document. One is that of due diligence and the other is of a disclosure. The due diligence requirement requires the endorser to ensure that any claim that is being made by a brand in content posted by the endorser can be substantiated in an objective manner by the brand itself. The know-hows also recommend that the endorser should have actually used or experienced the product or service. On the disclosure aspect, endorsers are required to disclose the fact that content is posted on behalf of a brand is advertisement or sponsored content. They can either use words such as advertisement, ad sponsored, paid promotion, etc. And these disclosures should be made in a very clear and prominent and hard to miss manner. The know-hows also require that these disclosures should be made in language which is the same as that of the content. The know-hows in an illustrative manner also set out what is the nature of disclosure that is required to be made for different kinds of content. For instance, in case of an image or a picture, the disclosure is required to be superimposed over the picture itself. In case of a video, the disclosure should be made in an audio and video format. For a live stream, disclosures are required to run throughout the duration of the live stream in a continuous manner. The know-how document specifically states that the disclosure, to make a disclosure as part of the tools of a functionality of a social media platform is not sufficient, and this disclosure is required to be included in the content itself. Like I mentioned earlier, the know-how document is not an individual piece of regulation, but it expressly states that any failure by an endorser to disclose a material connection will attract penalty under the Consumer Protection Act. Penalties under the Consumer Protection Act are also set out on your screen. They are fairly significant if you note. One is a fine which may extend up to 10 lakh rupees or 1 million rupees. The other is a ban on the endorser from endorsing any products or services for a period which may extend up to 3 years. So that is the overall gamut that the know-how documents try to cover. Back to you, Tanu.
Great, thank you.
Great,
Let me just
thanks,
jump in here.
Ishan.
Let me just
Over
jump
to
in
you.
here and see if any of our members have any questions. I mean, once again, thank you to the Khaitan team. I mean, you guys are true experts. These slides have a tremendous amount of information and want to thank you for just the details here. If anyone has any questions, please feel free to come on screen or raise your hand. While we're considering that, Ishan, I have an initial question for you. It's actually two questions, but let's start with the first one. What type of due diligence do people need to do on the endorsers? And then beyond that due diligence, what sorts of things needs to be made public?
So any claim that is being made in the content itself is what needs to be substantiated, Jay. So it's very important that the due diligence scope also be limited from a brand's point of view as well, that extra disclosure is not made. Only what is being claimed as part of the content is being substantiated as part of the disclosure that is being made to the endorser.
Okay, thank you. So how do things that are not necessarily factual, like, hey, I love Gujarat, come visit it. You know, I could just see Big B doing something like that. How did those fall in there? Are those opinions and not factual based?
That's correct. Those are opinions. And also a lot of these statements, it's also from a reasonable person's perspective that if there is a superlative statement being made, for instance, I enjoy Gujarat, that is not something that requires substantiation. Whereas a factual statement being made or, for instance, the effectiveness of a product being set out, then that is something that requires substantiation.
Thank you. And can you share a little bit more about, it seems like these are notionally voluntary, but if you violate them, you may be another government agency that fines you. Can you kind of help us understand, are they voluntary, are they mandatory, or somewhere in between?
No, Jay, so they are mandatory. This know-how
Okay.
document is more of a awareness creation and knowledge building exercise from the Ministry of Consumer Affairs. They essentially emanate out of the regulation and the Consumer Protection Act itself. And there have been a lot of efforts recently from the Ministry of Consumer Affairs to create awareness amongst influencers, because there have been multiple instances of misleading advertisements and misleading endorsements, especially on the digital side.
Wonderful. Thank you. Thank you. So I want to go to gaming. And again, if any members have any questions, this is your opportunity here. So there's a huge amount of excitement around gaming in general. So, but now this issue is fairly, very tactical. It's in the weeds. So I'm going to ask sort of a focused question on taxes and then a bigger question about its impact. So on the tax issue itself, I know there's an issue around net winnings. How does that work across platforms, right? So usually I would think gamers are operating on multiple platforms. They may win on this one, may lose on that one. How do we handle that?
So Jay, that's a very interesting question. And while the concept of net winnings is yet to be prescribed, there's been a media interview of the Direct Tax Board head of India post this budget proposal, wherein he's also laid importance on the set-off of losses of one game with the winnings of another. So while one remains hopeful that the competition may provide for it, but one will have to wait out till the exact competition mechanism is rolled in fine print.
And presumably the user would have to keep track of all of this. So if if they're competitive and they're playing with multiple games and on multiple platforms, at some point at the end of the year, they're going to have to sit down and figure all that out and then file.
That's right, Jay. So if the competition allows for set-off of losses, then they will have to keep a track of all the winnings and the losses they've made and then file the tax returns at the end of the financial year.
It sounds like an opportunity for some sort of SaaS platform to help people keep track of their winnings and losing. But more importantly, if you look at some of the taxation, there's always this counterbalance where tax versus untaxed versus trying to grow a sector. What's your take? Are the tax levels, are the taxation, are these notional, nominal, or is this going to be something that might impact the growth of the overall sector?
So Jay, I think very clearly what the government has tried to do here is bring certainty. The tax rate of 30%, which was initially in place, still remains as 30%. So there's no increase in that. They've tried to bring certainty, as was done with the crypto taxation earlier, wherein there were definite provisions introduced so that everyone is compliant and everyone knows what to follow. Similar has been the approach here towards the online gaming industry, wherein a consistent and more adaptive approach has been followed.
Great, thank you. Switching gears over to Abhinav, I'm trying to really understand this new sort of license. I made a mistake on the chat. The entry level is really low. It's $2,400 US. What type of companies are we anticipating are going to do this? Is this for data centers? Is it for OTT providers? Is this for app providers? Kind of help us understand who might be utilizing this new license.
Okay, so these entities, we should firstly refer to the IP1 entities who are already existing. They provide fibers and telecom towers to telecom licensees only. They do not cater to data centers or other internet companies, for example, or app companies. They provide infrastructure only to telecom licensees. The addition that is envisaged in this license is, apart from passive assets, they will also provide active elements under this license, but they will provide them only to either telecom licensees, to another DCIP entity, or to IP1 entities. So the universe is still restricted to these three entities only. The purpose is, like I was mentioning, to alleviate logistical and operational stress on the telecom entities. But again, this will lead to demergers and demergers of the active undertakings of these telecom entities, leading to investments. But then
Okay.
overall, the whole ecosystem will be benefited. It will eventually affect everyone who uses internet.
Okay, thank you. And how does the whole AGR and the AGR sort of and other sorts of taxes sort of impact this? Presumably these entities still would have to pay those?
No, so even though TRAI is proposing a license framework for these entities, but that is only for certain security related conditions and compliances. In fact, TRAI has said that like the current IP1 entities, no license fee will be applicable on these entities. And like we saw, the entry fee is also quite low. So there will be a lot of new entrants. Current IP1 and telecom licensees will be hiving off their entity, their businesses. So we are expecting a lot of activity in this sector if this goes through.
Thank you. And this appears to be sort of a business to business sort of setting where
Yes.
they would sell to the telecom service providers. Is the government considered any other model that would allow directly selling to consumers in order to try to add one more mechanism to develop infrastructure and user infrastructure?
Yeah, that's a very good question, actually, and it has been done. So if you refer to back to my slides, under bucket 2, you would see that there's something called a UL VNO license. And you will see that they only provide the service, whereas the bucket 1 entities provide network service and infrastructure. They can deal in all three. VNO licensees, they deal in the service, but they rely on the infrastructure of the unified licensees under bucket 1. They ride on to their infrastructure. But this did not take off because the full-fledged telecom licensees under bucket 1, they're not interested in enabling their competitors.
Interesting, interesting. I have to share that topic of VNOs came up in a recent conversation with the government of India. In particular, in the United States, the VNO market has done pretty well. And so there were questions about why it's worked in the US and why there has not been a lot of uptake in the Indian market. But perhaps that's a conversation for another day.
Yeah.
As we start closing out, Super Team, I want to come back to you and make sure that I have one final question on the grievance council, on the grievance committees, right? One of the things that we potentially see here is volume. What's your take? I mean, is this going to be like a low volume sort of activity, or is it going to be a super high volume? In other areas, whether it's TDSAT or in the IPR world, there's been criticism that we have these alternative mechanisms, and then all of a sudden they just have a huge caseload and backlog, and they don't really get resolved. Can you share any insights from your experience? Do we think that this is a viable mechanism? Do we think there's going to be a huge volume? Do you think we'll clear them, or is this just going to be one more, area where there's just a long cluster of cases pending?
No,
An
I
easy
think
final question for you, sir.
Thank you. No, I think we are crystal ball gazing right now, but you can imagine like the way it is applicable to all kind of intermediaries. There could be definitely a possibility of heavy caseload. You would see, ordinarily, any kind of complaints and grievances come to these platforms, right? Whether it is resolved correctly or not, the end user would probably always opt at least to try and see if it can be resolved through GAC or can be at least put up to GAC. So to my mind, definitely there'll be a huge workload, and I don't know whether 3 GACs would be able to handle this in future. The uptick may be a little slow, but I think if it gains traction, going forward, it could be like high volume game.
And dare I ask one final question? Who pays for all of this? Who pays for the operational fees and court cases? And presumably people may bring lawyers and things like that into these settings.
Right. I think for the individuals, it will be such individual. But if platforms definitely, I think again, will have to defend themselves and going ahead. I think that's how it'll play out. There's lack of clarity right now, and we'll have to see how this plays out. But I guess that's how it'll be.
Okay, thank you. And is it fair to say that this is a model that, if successful, might be leveraged in other segments in the digital space?
Oh, yes, yes. I think if you look at it, I think that idea has been already been there in some of the other pockets. So in case it works out well here, probably it could be replicated in other pockets as well.
Great, thank you. Well, this is our last call for any member who wants to come online or ask a question or raise your hand. Well, let me thank you, Tanu, and all of the experts from Khaitan and Company. This was a great session. You guys are super knowledgeable. Thank you for spending your invaluable time with us. We will make these slides available. This session itself is recorded and will be on USIBC's YouTube page shortly. And if you'd like to connect with any of the legal experts here, don't hesitate to reach out to us and we will make that happen. With that, I want to thank all of our members and participants for joining. We hope you find that these are useful. Please share your ideas going forward for other topics that we may cover in the future. And with that, please enjoy the rest of your evening in India and have a productive day in the United States. Thank you
Thanks,
and goodbye.
Jay.
Thank
Thanks
you.
very
Thank you.
much.
Thanks so much.
Thank you, everyone.
Thank you.